All right, everyone. Well, thank you for joining us this afternoon for another live briefing. And we, as always, when it comes to topics like this and other compliance areas as well, we love to have kind of an intimate discussion. And that's what this is about, this live briefing. This particular one gets into really a moving target with things that are happening, a very, very politically charged topic, but we're staying clear of that. So we'll take it for what the ruling is and how we're going to help you navigate it. So what are we talking about? First of all, I'm Brian Feely, Senior Vice President of Marketing for Corporate Synergies, and we're joined today by Dan Cooperstein, our Senior Vice President of Compliance, and Pamela Smith, who is our Senior Vice President of Account Management. And we're going to be speaking about the SCOTUS decision, the recent SCOTUS decision to overturn Roe v. Wade, and what that means for plan sponsors, employers, and how can they still offer, these are some of the questions, how can we still offer abortion benefits and related services, and make sure that they're not violating any state laws that are out there, any anti-abortion laws. And that's a very complicated question. And of course, as it relates to that, Pamela Smith, who's out there in the field, is receiving a lot of these questions, as is Dan. So kind of non-typical for how we do this. I'm going to turn over the questioning to Pam, since you kind of have captured most of these. Dan will be the authority on the call to kind of navigate this for us. And then I'm going to also monitor chat. So as you hear what we're discussing, if you have a question or you're asking for a clarification, I'll monitor the chat and we'll go ahead and we'll seek clarification where needed. So with that, locate the chat all the way down at the bottom of your screen. I'll take a look at that. And with that, Pamela, why don't you start things off?
Okay, thanks, Brian, appreciate it. So yeah, we've gotten lots and lots of questions from clients, great questions. We spent some time putting them into the most commonly asked and organizing them into a hopefully something that you'll really be able to take away a number of important ideas for your organization. So what's the first most common question that we're getting is, are there options to cover abortion related travel and lodging expenses for employees who are seeking an abortion outside of their state due to new state regulations? The answer is yes. Options exist. And then they really vary based on the employer's health plan, whether the employer is fully insured or self-funded. So we're going to go through some of the options. The next question is, what options are currently available for abortion related travel and lodging expenses? So they really fit into 4 different categories. So the first category being providing reimbursements through an employer-sponsored medical plan. Currently, this is an option for self-funded clients only. So that's an important distinction. And it's for their medical enrolled population only. So another important distinction. Notable that fully insured and self-funded plans can still cover abortion and abortion services in states where abortion is lawful, but fully insured plans will not reimburse abortion-related expenses for individuals traveling out of state. So that's the distinction there. So what are the other options for a fully insured health plan? You can provide reimbursements through an HRA arrangement. There are two different HRA arrangements that are available. One is a group medical or an integrated HRA reimbursement. And that would also be for the medical enrolled population only. So that's an important distinction there. And then the other option is an accepted benefit HRA or an EBRA that's not integrated under the ACA. And all eligible employees would be eligible for reimbursement under a type of plan like this. But it's notable that the reimbursements would need to be under $1,800 in order to remain compliant as a pre-tax option. So Dan, do you want to talk a little bit about that piece? Because I think that's important for everyone to understand as a distinction.
Yeah, that's a great point. Yeah, so right, there's 2 main types of HRAs that are being used right now for reimbursing the travel and lodging expenses, right? The group medical HRA, or maybe someone's referred to as like a full purpose HRA, right? That under the ACA is required to be integrated with a major medical plan. That's, I think, what most people probably think of when they think of an HRA. And then, of course, there's this accepted benefit HRA, which is a newer type of HRA or EBRA that you do have to still be eligible for a major medical plan, but you do not need to be actually enrolled in that major medical plan to get access to the HRA benefit. And you can get up to, like Pam mentioned, $1,800 per year for reimbursement. And there are some other requirements for all HRAs, which are important to note. Right, all HRAs are considered to be group health plans providing medical care, and they do so. In light of that, they require an ERISA plan document. So if you already have an ERISA WRAP plan document, you can amend your plan document to include this. But that is a requirement under ERISA, and also they have to be COBRA-able, right? They're subject to COBRA, right? So if someone terminates employment or their hours are reduced, things like that, they would also have to have access to that as well. And we can talk a little bit more. I know we're gonna go into a little bit later, probably some other things that we can do, but the accepted benefit HRAs, I think, are very flexible, especially if you have a high deductible health plan with an HSA, and we can talk more about that later.
Hey, Dan, going back to the HRA a second, we have a question. Would the dependents be eligible for reimbursement under the preferred benefit HRA?
The accepted benefit HRA, or
this is from Rachel. Would dependents be eligible for reimbursement under the preferred benefit HRA?
I think she probably means the general. I think it just depends on the terms of the HRA, but yes, generally speaking, if it's a general purpose HRA, yes, just like any other HRA.
So imagine it's general purpose. Imagine you don't have an HRA, okay, and so now you're faced with this, and you want to be able to offer it. Can you offer that mid-year?
Yes, you can offer. Yep, you can offer it mid-year and have an open enrollment. So 100%. Yeah.
And just to qualify, Rachel is saying she's speaking about the HR, where the one that does not require the employee to be enrolled in the benefit.
Actually, it's a good question. I'd have to actually double check, but I believe you can. I'd have to double check. There's a lot of requirements for accepted benefit HRAs, so I would assume yes, though, but I'll double check.
Okay, and that's a good point to make right now. Whereas your questions, we are going to capture them, and if you provide your email, yep, we will go ahead and we'll make sure that we answer something if we need to clarify it on the call. And a lot of times there's questions that we have not yet fielded. So it may be the forum where you pose a question we have not yet received. We'll seek clarification and then we'll get back to you for sure. Yeah, but, okay, good point. Thank you, Rachel.
Yeah, so the other two sort of basic categories for reimbursements are a little less probably prominent in what we've been talking about with our clients, but one is providing a reimbursement through an EAP. So it's actually interesting because in some respects this might be the best option. Because it eliminates some of the things that we were talking about. You could offer it to your entire population, and you may be able to offer it tax free. But the interesting part about it is that there are potential regulatory hurdles on this option. I'll ask Dan to talk a little bit more about that, but because of the regulatory hurdles, we haven't seen many options like this in the marketplace today. So Dan, do you want to talk a little bit about why an EAP, why we're not seeing that from an EAP perspective?
Yeah, so an EAP, an employee assistance plan, is what most people think of. Typically these are used for psychological counseling and things or services like that. Typically, they're offered incidental to or as a part of a major medical plan. So people probably aren't really thinking of this as an option for the reimbursement of travel and lodging expenses related to an abortion. But one way to do this would be to set it up as what's called an accepted benefit EAP under the ACA. So while this would still be an ERISA plan, and like the HRA, you would still need to do a plan document or amend your WRAP plan document to include this type of EAP. you'd have to meet certain satisfy certain regulatory hurdles to qualify as an accepted benefit EAP, which under the ACA, so they wouldn't have to be integrated, and that's just going to make it easier to offer alongside your existing plans. For example, if you have a high deductible health plan with HSA, this is going to make it more like an accepted benefit HRA, in that you'll be able to offer it without eliminating your eligibility for that HSA, which is a concern that you have with the HRA. So going back to what are those 4 big hurdles, right? Well, the first one is it cannot provide significant benefits in the nature of medical care or treatment. And the second one is that it cannot be coordinated with benefits under another group health plan. So this is like a non-integration rule, right? It cannot be integrated, like unlike the HRAs, which require integration, this one cannot be integrated, and it cannot charge a premium for participants, and it cannot require any cost sharing for offered services. So if you satisfy those requirements, then you can qualify your EAP as an accepted benefit EAP. But one of the big problems out there, I think, is that first of those 4 requirements, which is it cannot provide significant benefits in the nature of medical care. Since that really hasn't been defined, there's no case law on that. There's no like history of what that exactly means, or no sub-regulatory guidance or anything like that. We really don't know what it means. Presumably if you're just doing travel and lodging expenses, doesn't sound like significant benefits in the nature of medical care. So because of that, this seems to be like an excellent option from a regulatory compliance standpoint, but we haven't seen that much really. We haven't really seen the vendors really coming up with a lot of options, probably because they're concerned with that first regulatory hurdle there. And Pam, you want to talk about some of the things yeah, go ahead.
Yeah, just on that, do you see, obviously every time we have one of these, there's always the gray areas, and we don't have fully clarified rules and what have you. But on this, and given the light on the focus on this, do you see that particular requirement being clarified anytime soon? Or are you hearing anything through your advisory councils that, hey, it looks like this is going to be clarified through this, case law, whatever? Anything that you're hearing on that?
It's actually a good point, because I'm involved in a lot of other attorney groups, and I'm involved in the New Jersey State Bar Association Senior Employee Benefits Committee. I talk to a lot of lawyers, in our industry group, and I have not heard anything yet. I do think it would be certainly if it would certainly be something that probably I'm assuming the Biden administration probably would be exploring it, along with a number of other options that they're looking into right now, and to make access to the care more accessible, which I know is one of their priorities. So it could be something that's being considered by the Biden administration, but I have not seen anything come through yet, okay. even proposed rules or guidance or anything.
Okay. Tam, what else are we hearing?
The fourth bucket is the taxable reimbursement program. So, you can offer a reimbursement for employees that's taxable. That is also an option. Not one that we recommend, but it is an option out there.
Yeah. I can talk a little bit more about this too. I mean, we talk about this in our e-alert as well. It would not be our first choice, I think, for a number of reasons. One of the major concerns out there really is privacy concerns, because many times taxable reimbursement programs are administered through the employer itself. And whenever you do that, you raise the potential for violating privacy rights, privacy laws, as well as increasing the allegations of potentially of employment discrimination lawsuits, because someone says, well, you only fired me because I was pregnant, or because of my disability that required me to terminate my pregnancy, things like that. And that's typically how those things are administered. And then the other concern, of course, with taxable reimbursement is that there is some risk that if you're not doing it carefully enough, upon an audit by, and I have seen this in defending some audits, the government agency could say that it was supposed to be a health reimbursement arrangement, and this is a de facto or unintentional HRA, and therefore, because you didn't do a plan document and you didn't comply with all the HRAs, that can create a problem, and that can be risky from that standpoint as well. But there are, Pam, maybe you could talk a little bit about that. I know there is at least one vendor we know that is, offering to administer that outside of the employer.
Yeah, I guess actually that probably fits more into the HRA or EAP space. But if you are offering sort of a parental benefit, some of the vendors out there are Maven, Carrot, that they're also offering these programs. So it's definitely something to consider when you're looking at your options to see if your parental vendor might offer that as well. Parental support vendor. So I think we should shift gears because while we just talked about the basic categories of the options that are available out there, what I think we also need to spend some time on is the major considerations that employers should be thinking about as they're making decisions in terms of whether or not they'd like to cover a benefit like this. And one of them, is whether or not you offer a high deductible health plan. Because if you're going to be offering a reimbursement under the medical plan, they would be those reimbursements will also be subject to the deductible. So that's definitely something to consider, and that's whether it's under the first option that we talked about, the self-funded medical plan option, or the integrated medical plan HRA option. Both of those would be impacted by that. But the accepted benefit, the EBRA, would still be an option if you had a high deductible health plan, because it's an accepted benefit. So that would still be a consideration for you if you were offering a high deductible health plan.
Yeah, just to clarify something there. I think you meant to say, you may have just misspoke just a little bit, but I think one clarification is that if you have an HSA that's offered with your high deductible health plan, enrolling in a full purpose HRA renders you ineligible to contribute to the HSA, the health savings account. I know there's a lot of acronyms out there, so I hope I'm not confusing people. But
no way to avoid it, Dan. It's okay.
Yeah, exactly. It's the nature of the business we're in, right? So HSAs, it's not just you, the participant, your contributions as the participant, but also your employer's contributions. You've rendered that HSA ineligible for any of those contributions if you enroll in a full purpose HRA, right? So that's why if you have a high deductible health plan with an HSA, the EBRA, the accepted benefit HRA, or the accepted benefit EAP is a much better option if you're one of those employers doing the high deductible health plan HSA. So sorry to throw a ton of acronyms out there, but just wanted to kind of clarify a little bit there. And I think, man, that's probably what you meant to say, right? You were just kind of talking a little bit about that as well, right?
Right. Yeah. So, and actually, Dan, thank you. Good point. That, you can have a high deductible health plan out there without an HSA contribution or without contributing to an HSA. So that would be outside of this discussion. So the other option is just financials. So, how much is the program going to cost? How much should we be reimbursing? What is the scope of the services that, and we'll get into to that as a sort of a separate consideration as well on the scope of services. But how much is this type of plan going to cost your organization? And the scope of services is very important because these benefit plans shouldn't be limited to just travel related reimbursements for abortions. They really should have a larger scope of service than just that. So Dan, do you want to talk a little bit about scope of services?
Yeah, and I think that's a really good point. I think so. We have to kind of go back a little bit. I know, Brian, we wanted to do a kind of a very brief introduction and not waste a lot of time on that. But what are the main reasons for why we're looking at these options, right? I think the concern is that, right, as an employer offering abortion care under the health plan, there's the potential for liability if people go to out of their state, right, to get an abortion, and the plan is sued, right? The employer sponsoring the plan, and the plan is sued for maybe aiding and abetting, right, an abortion out of state or doing something else that violates a state law. Now, generally speaking, all of the plan documents and the certificates of coverage that are attached to the plan documents should already make clear in there that abortion coverage and abortion related reimbursement is only applicable to abortion in a state where it is lawful. But what's made this whole thing much more confusing and concerning is that at least two of the states so far, Texas and Oklahoma, have created aiding and abetting provisions in their statutes. These are criminal state laws that prohibit people from essentially cooperating or helping someone else to participate in an unlawful abortion, even if it's out of state, right? So they have extraterritorial application in these state laws. And so the concern that a lot of employers have, and the reason why they're being so careful with what you can and can't do, is because none of our clients, every single client I've spoken to, right? No one wants to be the one that's the example, right? No one wants to be the one that Texas decides they're going to sue for aiding and abetting. And I think that's where we have to kind of look at the way that these things are structured when you're setting up an HRA or other reimbursement program to reimburse travel and lodging. You don't want to be come under the radar of one of these states. Now, granted, right, it's probably very, very, very unlikely that would happen. Right? Some of the largest companies in the country, even before the Dobbs decision was announced that overturned Roe v. Wade, even when that leaked draft came out in May, already announced that they were going to be doing very big reimbursement programs. But they'll hire that reimbursement program, and the more limited that is to just abortion-related travel, I think the more likely you are that you may be the one employer that the state decides to make an example out of, right? Now, there's another issue there, of course, with ERISA preemption. And that we could probably do a whole nother compliance briefing on that. But essentially, the way, and there's been no case on this, and this was not a part of that Dobbs decision that overturned Roe v. Wade, but there's a question as to whether if you have an ERISA plan, does that preempt any state criminal law about aiding and abetting? And I think certainly a good case can be made that it does, but there just hasn't been a case yet. But in any event, outside of ERISA preemption, that is one of the major concerns I think employers have, is aiding and abetting. But there's also another consideration, which we'll talk about more on the financial side, of IRS qualification. And so if what we've seen with some employers out there, that are offering $10,000, $7,500. Right, there's a concern that you might be going, you're paying for elaborate vacations, right? You're paying somebody a lot of money to maybe go to Hawaii to fix a hangnail or something like that. And those, I think, draw the question as to whether under the Internal Revenue Code, that reimbursement arrangement is truly for health, medical purposes when it gets that high. And so what we've seen, and I also have spoken to other attorneys out there who've been advising on this, they're tax attorneys, they're recommending to kind of go a little bit lower, no more than maybe a few $1,000s, maybe $3,000 or $4,000, to kind of avoid that potential that the IRS may say this isn't related to just medical care. Now it's like a vacation thing, and it's not for what it was intended to be, and therefore we're going to disqualify in your plan, and you lose the tax favorability of the plan. So I think those are some of the two big kind of considerations that are out there.
So don't draw attention to yourself in
Yes.
all of those areas that you're speaking about.
Exactly. Don't draw attention to yourself is the best way to summarize, right? Exactly.
And the
I
language,
didn't even have an acronym for that.
No, I love it. Yep.
yeah, the language that we're mostly seeing, in these provisions is, for travel expenses related to reproductive services, and also for mental health, because it's important to remember there is the Mental Health Parity Act. So, your language has to comply with the Mental Health Parity Act. So those are definitely two things that we're seeing in the language, sometimes more expansive than those two, but really important to work with your benefits of consultant to come up with language, and your labor attorney and your employment attorney to come up with language that that really reflects the benefit you're trying to offer your employees.
Exactly. I think one of those, it goes back to what we were saying before, right? If you're only drawing it very, very narrowly to just women who can get abortion travel expenses, in addition to, of course, the aiding and abetting concern, there's also the concern that the men may allege that it's sex discrimination, especially if it's a very favorable benefit, and may say it should be open to all reproductive health care And especially that's, I think, especially important if you're in a unionized or litigious workplace environment.
Just before we get too close to the end here, we've got about 4 minutes left in this briefing. I want to draw attention to the fact that this briefing, along with other compliance information and other events, will be made available. Of course, you can follow all of the compliance information on our LinkedIn channel, Hawk, where this recording will also be available. And don't forget the Compliance Resource Center, also available at corpsin.com, our website. Tons and tons of information available to you there. Like, you'll find a lot of Pamela Smith articles in there as well. So Pam, great job. I think you just had one recently published, if I'm not mistaken. So congrats on that. We do have another question. So how would states like Texas get access to the reimbursement from employers to be able to go after insurance carriers? Don't know if you would know how that's done.
Well, I think, it would, that's a very I don't want to get into the technical weeds here from a legal standpoint, but essentially any kind of state that's out there trying to start a lawsuit is probably going to request a copy of the plan document, right? Which would include, in the SPD, which would include the certificates of coverage that would explain what that amount is that's being offered as a reimbursement. And then they're just going to, it wouldn't even necessarily, it's not necessarily about those monies, but the bigger concern, I think, is just the criminal liability, right? I think that's the bigger concern, right? Going to jail. No one wants to go to jail, right? So they could recover the money pretty easily. I think the bigger problem for people, especially employers, is no one wants to go to jail. So
Brandon has a question. For employers with an existing HRA, are travel and lodging expenses simply added as an additional reimbursable expense under the existing HRA, as opposed to being a separate additional HRA?
Yeah, you can do that. You can always amend an HRA to provide that. Now, it may, from an administration standpoint, I'll defer to Pam. She probably knows much more about what the vendors out there are willing to do. I don't know if that's something, Pam, have you seen vendors willing to do that, or do they typically recommend just doing a separate HRA?
No, I think they're, an amendment to the HRA, as long as the vendor is willing to reimburse for those services, would work. I think the one thing that that we talked about on the call is just, do you want to amend your current HRA and limit the reimbursements to that population that that is enrolled in your medical plan, or do you want to have the accepted benefit HRA and open it up to a larger population? I think that's really the consideration for the decision there.
I'm trying to get another question in here, and it kind of speaks to some of the, where do we go from here, and what you may start seeing as a result of this decision. But Kate asks, what's the thoughts about including gender reassignment, since laws are being placed in some states to restrict? So, beyond abortion, gender reassignment, and then just maybe speak as we end this up about what else to look for that we're hearing about, to be on the lookout. So thoughts about the gender reassignment?
Yeah, that's a great question. I think that the Dobbs decision, there's no way to describe it other than seismic from a legal standpoint. We've really never seen anything like this before in Supreme Court jurisprudence. There was an opinion that came out after the majority opinion by Justice Clarence Thomas that said that he wants to look, want the court to re-examine, questions about gay marriage under Obergefell and contraception and other Supreme Court precedent. And so we're watching those things very closely, and it's possible that, this Supreme Court could lead, could make decisions that lead to other changes in the law that we're watching. So potentially changes, for example, to, gender assignment, right? Questions about medication abortion, right? Which is the prescription of FDA approved medications to abort a fetus, in which some states like Indiana and Tennessee have significant limits on. Potential changes to the contraception rules, right? The Supreme Court may say contraception must be regulated by the states. Potential changes to the dependent coverage rules, right? If the Supreme Court says that the issue of whether a gay marriage is lawful is something that must be determined by the states. So those are things that we're watching very, very closely. Now, the Biden administration has issued an executive order on July 8th, making it clear that despite everything that's happened, it will ensure that they will protect the right of a patient to travel to another state to obtain an abortion. And also the Department of Health and Human Services has recently issued an announcement that it will permit abortion under federal law in any state in the event of an emergency that threatens the life or health of the mother. So we are seeing a little bit of a federal response. We're watching those developments very closely and posting those to our compliance resources page. And I believe there will be another compliance briefing talking about some of these other developments as well, and potentially a webinar as well, going through some of these things.
Well, to that end, and out of respect for everyone's time, we're going to end it here, but we're not going to end the discussion. Clearly, this will be something that we will continue. Take a look at our events page, take a look at our compliance pages. We'll be in touch. Check out our e-alerts and what have you. Dan, Pam, and the rest of the group are going to be really staying close to this issue as well as many others. So we appreciate your time. Thanks for joining us. Remember, check out our resources. This will be videotaped, or it's already captured, and we'll make sure that this is available should you want others to take a look and listen into the guidance. All right. Thanks, everybody. Have a great afternoon.
Thank you.
Thank you.